Good afternoon, everyone. Hopefully you can all hear me. So thank you for joining our webinar today. I'm Emma Waldron, WCVA's Risk, Procurement and Governance Manager, and I'm also WCVA's Data Protection Officer. Data Protection for Trustees is the 7th webinar of the Desktop Data series. And this session has been created in light of it being Trustees Week last week. So a lot of the audience today, I imagine, are trustees, so welcome to our session. These sessions have been arranged to help you prepare for the new General Data Protection Regulation, GDPR, which comes into place in May 2018. And I'm delighted once again to welcome our speaker, Bethan Bonsall from the ICO.
Hello.
And Bethan's here to discuss data protection for trustees. We anticipate today's session taking approximately half an hour, and there'll be an opportunity to ask questions throughout and at the end. There will also be an opportunity to share your comments by completing a short survey, which we will share the details with on the final slide. Okay, so over to you, Bethan.
Thank you, Emma. Good afternoon to everyone. Prynhawn da I bawb, and thanks to all the trustees who are joining us today, and also those who will be watching at a later date. When I was having a read last week about the events taking place across WCVA to mark Trustees Week, it really struck me how important your role as a trustee is and how essential your role is going to be in terms of helping the charity that you represent comply with the laws that the ICO regulates. This webinar aims to equip you with the relevant information and make you aware of the ICO resources available to help you in a time of data protection reform. Before we go on to look at how you can help your charity comply with data protection laws, let's look quickly at the role of the ICO and see how the data protection landscape is evolving. Thank you. The Information Commissioner's Office is responsible for regulating the Data Protection Act, which governs how charities and all other organisations in the UK should handle the personal data that they collect and use. And we also regulate the Privacy and Electronic Communication Regulations, which set out rules that you should be following if you're instigating any direct marketing by electronic means, so things like emails, fax, telephone marketing. So whilst we'll be touching on direct marketing during this webinar, those of you who want to find out more about direct marketing and the privacy regulations can watch a previous desktop data webinar that we ran back in September, which breaks down what your charity needs to consider in more detail when running any fundraising or direct marketing campaigns. The ICO has a head office in Cheshire, which is the office that you can see on the screen, but we also have offices set up in response to devolution in Scotland, Northern Ireland, and indeed Wales. So I'm the lead policy officer for the ICO's office in Wales, and a large part of my role is to work with charities like yourselves across the country to help you with your compliance under the laws that we regulate. So for that reason, if you've got any questions in your capacity as a trustee after this webinar, I'm always more than happy to help and would encourage you to use the ICO's office in Wales if you do need any advice or guidance, and I'll be putting my contact details up at the end of the webinar. So when organisations face data protection issues, getting in touch and working with the regulator through various issues can often prevent things from going wrong. Unfortunately, though, when things do go wrong within any organisation and the Data Protection Act or the privacy regulations are breached, part of our role is to take action to ensure that organisations meet their information rights obligations. So as part of that enforcement power, we're able to issue undertakings which commit an organisation to a particular course of action in order to try and improve its compliance. We can issue an enforcement notice where there's been a breach, requiring organisations to take or refrain from taking specified steps in order to ensure that they comply with the law. And we can also prosecute those who commit criminal offences under data protection law. So one would be failing to register with us when required, or when an individual obtains or discloses data without the authority of the organisation. And as many of you will be aware, we can also issue monetary penalty notices requiring organisations to pay up to £500,000 for serious breaches of the Data Protection Act or indeed the Privacy and Electronic Regulations. The main focus of the webinars we've been doing under the Desktop Data series with WCVA has been to help charities prepare for May 25th, 2018, which is when the Data Protection Act will be replaced with the General Data Protection Regulation, or GDPR for short. The change is the biggest that we've certainly seen in a generation, and your role as a trustee can help the charity you represent prepare for this change. The key thing to remember is that those organisations who've got a good grasp of the current law will find themselves in a much better position come May next year, whereas those who don't may find themselves in a panic the closer they get to that date on the screen, so the closer they get to 25th of May. And as a trustee, you're able to guide your charity to ensure that you're meeting its obligations under the current data protection regime and, as of May next year, requirements under GDPR. So I think it's always nice to get a bit of audience interaction, just to make sure you're all still with us. So I just want to do a quick vote by typing in the comments box. I just want to get a feel for whether you as a charity have started to put any measures in place to comply with GDPR, so whether it's been on your radar for a while, whether you've started to change policies and procedures, etc., staff training perhaps. So please don't worry about what you answer, because I'm not taking this away with me. We're not going to use it for intelligence purposes. This is just for me to get a feel for how prepared you feel you are, whether you're on that road to compliance or you're only starting to look at it now. So if you're happy to type in whether you've started to do certain things and you're happy to share that with us, then that's great. And if you haven't, then it's just to reiterate that now is the perfect time. So if you haven't started making steps, hopefully this webinar will help and we can signpost you to the resources that will be helpful. I'm just having a little look at some of the responses. So, I mean, it's brilliant that you're honest, because if you're just starting now, then the good thing is that you're starting. You signed up to this webinar, which is a good sign.
Yeah, it's great news looking at it, Bethan, because it looks like a lot of people have only just started or are starting, and yeah, started taking steps. For example, webinars, etc., been on the radar for a while, just starting to look at it. Excellent.
That's really positive. And again, if you're feeling a bit overwhelmed and you're thinking, I haven't started taking as many steps as other charities, then there's a wealth of resource. There's the desktop data webinars that we've done. There's guidance on our website, which I'll be linking to. And you've also got the ability to use this as a regulator. So that's really good. There's training for staff and trustees. Brilliant. Thank you for being so honest. That's certainly really helpful for me to gauge how much of GDPR you'll be aware of. But again, there'll be scope for questions at the end. So if I do go through this and you think, well, I've still got a certain question, then we'll happily answer them at the end. So let's take a quick look at what is on the data protection horizon and why the GDPR should be viewed as a positive change. So I think it's important to stress that GDPR isn't something to be frightened of. It's something that we certainly welcome in the ICO, and we'll cover the reasons behind GDPR coming in. So one of the biggest drivers behind GDPR is the increased rights that individuals will enjoy in relation to their data. Some of the rights that you can see on the screen are new, whereas other rights already exist under the current data protection law, but they're strengthened in a few ways. So you can see a list of those GDPR rights on the screen, so all 8 of them, and you can find out more information about the specific circumstances that each right will be kind of involved in our overview of the GDPR document, which I'll link to later on. But just an example of how existing rights are strengthened, one example would be that second right that you see on the screen, so the right of subject access, and that's the right that allows individuals to request copies of their personal information held by an organisation. So an individual writes to you asking for copies. It could be all information or just certain bits that they're interested in. And that's a right that the current Data Protection Act gives individuals, but under the current law, you as a charity and all other organisations have 40 calendar days in which to respond. And at the moment, you're entitled to charge a fee of up to £10 for that request. Under the GDPR, the time your charity will have is reduced to 1 month, and that ability to charge a fee will be removed. There'll be some scope to charge reasonable admin fees in a small number of circumstances, but that ability to charge for personal data requests on a blanket basis is removed. So that's an example of our rights as individuals being strengthened. An example of a new right is the right to be informed, so the first right that you can see on the screen. And so despite being a new explicit right, it is actually an extension of your current obligations when you're telling people as a charity what you're going to do with their information. So when you're collecting information from donors or staff, etc. So it's therefore essential that you look at what your charity is currently telling donors, service users, or anyone else that you hold data about. It's key that you're currently looking at what you're telling them now. And again, there is a useful section in our overview of the GDPR document. And we also ran a webinar in August called Privacy Notices and Consent, which did actually cover the type of information you need to be telling individuals when collecting and using their data under GDPR. But just remember that it's an existing kind of implicit obligation, but under GDPR it's an explicit right that individuals have to be informed of how their data is being used. When we're talking about the rights that individuals have in relation to their data, so the rights that we saw in the previous slide, what type of information is covered? Like the Data Protection Act, it applies to personal data, which is basically data that identifies a living individual. However, the GDPR's definition is slightly more detailed and makes it clear that information such as an online identifier, so for example an IP address, can be personal data. The more expansive definition of personal data under GDPR really does reflect the changes in technology and the way that organisations, so we as organisations, collect information about people. And if you think about it, the way that we were collecting and using personal data when the Data Protection Act came into effect 19 years ago has changed quite significantly. So this wider GDPR definition of personal data aims to reflect those changes. So if you just have a little look on the images on the screen, things like CCTV footage are covered, biometric information like fingerprints, and indeed audio recordings as well. So a lot of people make the mistake of thinking that data protection and GDPR will only apply to information that's in on a computer, for example. But this screen hopefully emphasises the fact that it can be any type of data that relates to a living, identifiable individual. Similarly, like the Data Protection Act currently, the GDPR is based on principles of good information handling practice. By having a good grasp of these principles and how to comply with each one, you'll go a long way as a charity in terms of helping your organisation comply with the law. So let's take a look at these in a bit more detail. The first principle that you can see on your screen states that personal data must be processed fairly, lawfully and transparently. So charities must be transparent as well as fair and lawful in their use of personal data. The transparency issue is quite key here if you think back to the enforcement action that the ICO took in relation to charities a few months ago at the beginning of this year and their wealth profiling practices. So the profiling was taking place without the individuals being made aware, so it wasn't in a transparent manner, and it's that led this principle to being breached because it wasn't fair to those individuals that their data was being used in a way that hadn't been made aware to them. The next principle links back to transparency and legality. So you must have a legal basis for processing data and you need to explain to people what that is. So it's not just enough to say, I want this data, I'm going to collect it. You need to have a valid legal basis under GDPR, and that's very similar to your current obligations now in terms of the Data Protection Act, because in order for data to be processed lawfully now, you already need to meet a legal basis depending on the nature of the data that you're collecting. The next principle relates to the quality of the data you hold. So the data must be adequate for the job you specified, relevant to that job, and limited to what's necessary in order to get that job done. The next principle states that data must be accurate, so you need to have suitable systems for checking your data at appropriate intervals. So how often you make accuracy checks will depend quite largely on your purpose and also how critical the data is to the rights and freedoms of the data subjects. I think it's also key here in terms of the charity sector to note that there's a difference between ensuring data is accurate and actively finding out updated information from sources other than the individual. So for example, if a donor changes their email address and you get a bounce back, then simply updating their records to reflect that your email address that you hold about them is no longer valid is enough to demonstrate accuracy. So we've seen unlawful practices in the charity sector whereby the charity will actively seek out the new email address from other sources, so online or other sources available to them, which means that actually the charity starts to process the personal data of the individual without them being aware, and perhaps without the individual even wanting them to have their new email address. So it might be that they didn't tell you of their new email address because actually they've set up a new account and they don't want certain marketing emails from organisations. So there's a key difference there between having reasonable checks to ensure accuracy and actively going out and kind of matching or appending the data that you currently hold about individuals. Where you no longer need the data in an identifiable form, then basically GDPR says anonymise it at the earliest opportunity, and if you don't need it at all, securely destroy it. So you've got two options there. And this principle links strongly to the need for your charity to have robust retention schedules in place that are followed and reviewed at appropriate intervals. So it's not enough just to have a retention policy that sits somewhere on your intranet. You've got to make sure that your charity is following it and weeding out information when you no longer need it and then securely destroying it once that information is identified. And the final principle is very much like the data protection security principle, and the GDPR basically requires you as an organisation to take appropriate technical and organisational measures to ensure security. And that includes protecting against unauthorised or unlawful access or processing of that data, or accidental loss, damage or destruction. And we'll look at some of the measures that you can take in the next slide. And you'll note that text in green on the side that says accountability. The GDPR also creates a new pseudo-principle of accountability. And that means that as a charity, you must be able to demonstrate how you comply with the principles that you can see on the screen. So some of the measures you can take to demonstrate accountability will be discussed on the next slide. But the key here is that you're not just complying with GDPR, so you're not just following these principles, you're actively demonstrating by way of things such as policies and procedures, so back to my point about retention policies, and other ways that we will cover a bit later on. But it's not just complying with the principles, it's making sure that you're demonstrating how you're getting to that level of GDPR compliance. When I go out and about as part of my role as lead policy officer and I talk to stakeholders in Wales, many organisations, whether that's charities, different types of organisations, many organisations ask the question, what security measures do I need to take to protect the personal data that we as an organisation hold? Now, there's no straightforward answer, as the measures which would be proportionate to one organisation might differ quite significantly to the next, depending on the nature of the personal data that you're processing. An example would be a small jewellery maker selling bits and bobs at local fairs or on quite a basic website would hold significantly less personal data than a large charity collecting sensitive information about service users. So the security measures proportionate to the first organisation will be significantly different to those needed by the charity. So that's why there's no magic answer, unfortunately. But we do have guidance available. So the key to keeping information secure is to think of security as a wide term encompassing more than one element of security. So let's take a look at what kind of measures you can put in place. First of all, you've got organisational measures. So one of those would be to take stock of all the personal data your charity currently holds and ensure that you've got a valid legal basis under the GDPR. So it's back to your lawful processing. More information can be found in our GDPR overview guidance, so I won't go into much detail here, but it's similar to your current obligations under the Data Protection Act. So for normal personal data, you've got to meet one lawful basis in Article 6 of the GDPR. And examples of this include the consent of the individual or collecting personal data for the performance of a contract, which might cover most of the processing that you do with your staff. For the collection of special category information, which is innately more sensitive, so things like health information, your charity will need to meet a lawful basis under Article 9 of the GDPR. And again, more detail and advice can be found in our GDPR guidance, which I'll link to a bit later. Excuse me. Carrying out what we call data protection impact assessments at the beginning of any project or initiative is another way of ensuring security is taken seriously. So DPIAs, or data protection impact assessments, require you to consider data protection issues up front rather than having to retrofit compliance at the end of a project, which can often be costly and an ineffective use of staff resources. We've got a really useful privacy impact assessment code of practice on our website. Again, I think I screenshot that a bit later on, but I'd really strongly recommend familiarising with yourselves now what a PIA looks like so you can embed them into your practices before the GDPR comes in. So again, we'll cover that in a bit more detail later. We've referred to retention schedules already in terms of making sure you're not keeping data longer than necessary. And another organisational measure you can take in terms of security is having effective policies and procedures relating to data protection, but not just having those in place, so not just having them on your intranet buried on the deepest, darkest depths, but making sure you're communicating those policies to staff at relevant intervals. For example, if it's updated or it's a new policy, making sure that staff are aware that that policy even exists, and that's going to be key in terms of looking after the data that you hold. Technical measures are just as important in terms of looking after the data that your charity holds. So good IT security is essential, and being aware of what to do in the event of a personal data breach occurring will be crucial in terms of GDPR compliance. But it's also just as important under the current law, so again, it's not a new obligation. And we'll look at what a personal data breach involves in the next slide. Creating a strong culture of data protection awareness within your charity will help reduce the risk of something going wrong. So training should be relevant to each individual's roles and should be monitored and recorded at regular or appropriate intervals. If something goes wrong and you need to demonstrate to the ICO that you've trained your staff, but you can't demonstrate what training they had and when, then this puts you in a difficult situation of not being able to demonstrate your accountability. So again, back to that accountability principle. So looking at all these measures on the screen, paying attention to all of these different measures and issues will really help your charity reduce the likelihood of human error. So that little blob that you see on the screen, it really does help reduce it, leading to something going wrong with personal data that your charity holds. So the more you can focus on these issues and embed these into your practices, the stronger you'll be in terms of looking after your data. Now, I am aware that there's been a couple of questions already, and that's quite a meaty and techy slide. So I think it's probably nice if we stop to take some questions.
Yeah, that's fine. So give Bethan a bit of a break as well. There's a lot of talking obviously in this presentation. So if anybody has any questions at this point, then if you can just type them into the chat pane, please. So one question that's come through from Alison is that you mentioned about an overview of the GDPR document. Can you let us know how to get a copy of this, please? And I believe that's on the ICO website.
That is. I think the easiest way is probably going on to ico.org.uk and typing in overview of the GDPR. But I do believe that it's often on the home screen, so the home page. If you look at the section for organisations, it's often there already to click through. But if you've got any problems, then I think if you just search it in our search toolbar, it comes up straight away.
Sure, no problem at all. Okay, and if in doubt, we could always send the link out after this webinar anyway. Okay, and the next question was, will we have a copy of the slides? And the answer to that question is yes, you will have a copy of the slides. And you'll also have this webinar. This webinar will be published on WCVA's website. So you are welcome to obviously come back to this at any point, share with colleagues and fellow trustees, for example. Yeah. Okay, so a few people are still typing in. Just want to reiterate one of Bethan's points earlier on about policies. So, for example, I'm sure everybody has a data protection policy. Many may also have retention policies. And it's just key, really, to make sure that staff are very aware of the policies.
Yeah, I mean, that's going to significantly help if someone does lose data or someone does something to personal data and it goes wrong, and then the individuals affected complain to the ICO. Then as part of that complaint, we look to see what did you have in place to prevent that from happening. And if you can say, well, we had this retention policy, for example, in relation to taking laptops out of the office or moving case files between offices or meeting points, etc. If you've got a policy that helps staff know how to handle that data appropriately and what they can and can't do, what they do if they lose it, for example, then that policy is going to help significantly in terms of our investigation. Whereas if you turn around and say, well, actually, we've never told staff what to do if they lose a case file or if they take a laptop out and it gets stolen, for example, then there's, that policy really does help in terms of demonstrating your accountability. So back to that, I keep preaching on about it, but that accountability will be key.
Yeah, under GDPR it will absolutely, won't it?
Yeah.
Okay, and then just a few more questions, and then after these questions we'll go back into the presentation. So the next question, can you kindly recap on lawful basis for processing in relation to email?
Okay, so with when we talk about lawful basis, there's basically, you've got to meet a legal basis under the GDPR and under the current law as well, in terms of even starting to use that data. With marketing, so with email marketing, that basis is actually dictated in the privacy regulations that I referred to earlier. So if it's email marketing or if it's other types such as automated calls, etc., that basis has to be consent, because it's all about giving that individual control over how their data is used. In other areas, so other kinds of marketing, postal marketing might not be consent. It could be that it's under GDPR, you might decide it's your legitimate interest, but again, that would be a decision to take within each charity and see what's appropriate. But it's basically that when you collect data, when you start using personal data, you can't just collect it because you want it. You've got to have a valid basis under the GDPR, and that overview document will explain more of that in more detail, because it's quite hard to explain just kind of, in a couple of sentences. But I'm more than happy, if you've had a look at that, I'm happy for you to get in touch with us to ask us a bit more.
Okay, so I'll just answer the questions that are currently in the chat pane, and then we'll move on. So the next question is, do we need to record that we are destroying data?
So it's back to that retention policy. If you've got a clear retention policy that says, for this category of data, we will destroy it after 2 years, then that in itself says that actually after those 2 years, that if that data was created in 2015 on April the 1st, then it's likely that if a request comes in for it in 2020, you already know that you've securely destroyed that in line with your retention policy. So that's why it's very important to have a note of what your retention policy is and make sure you're following it as well, not just having it in place.
Okay, so from Denise, will there be a form to use in case of a breach?
There's a form on our website, but we've also launched a few weeks ago a helpline, which a lot of organisations prefer, I think, because you're talking to a case officer in Wilmslow. So by all means, you can carry on using the form on our website. There's already we've had a form for, years and years back, I think. But the helpline will be quite a new thing, and it's one it's getting quite positive feedback, because you've got that interaction there and then to talk to a case officer about what's gone wrong.
Okay. And from Heather, are there guidelines for how long data should be retained, such as emails, etc.? And then you've added, how long before they should be deleted?
Okay, so that relates to the importance of having your retention policies in place. And the retention policy you might have for one category of data will be quite different to another, such as emails. What we look for when we're advising about retention is, first of all, are there any legal guidelines or legal kind of statutory requirements to keep hold of personal data? If there is, so if it was HR, for example, or financial information, then that already dictates what your retention should be for that type of data. In the absence of a legal or statutory guideline, we would say, well, has your sector got any agreed industry standards? So have you come together as a group of charities or similar organisations and said, look, there's no legal guidelines, but we think that X amount of time is appropriate for X type of information. And then in the absence of those two, so you haven't got a law that says how long to keep it for, and you don't have an agreed industry standard, then the most basic question we would ask is, what's your business need? So what's your rationale for keeping hold of that personal data? And if you don't have a rationale and you think that actually we're keeping things just in case, but actually we don't ever need that information, then at that point it's really good to think, well, you're doing yourselves a favour if you get rid of that information, because if you're keeping it for too long, you risk breaching the principles. So, for example, if you keep it too long, is it going to be inaccurate? Is it going to be relevant to that purpose? Is it going to be fair to that individual? So you can see how the principles link up, and you can also see how key it is to have good retention schedules in place.
Okay, thanks, Bethan. And a final comment there from Rafat to say that templates of data protection policies can be acquired from your local county voluntary council. So, just a point there to note. And what we'll do now is we'll carry on with the presentation. In the meantime, if anybody has any questions, please enter them into the chat pane and then we'll capture them at the end. Okay, over to you then, Bethan.
Thank you. So we've looked at the types of measures to take against the risk of something going wrong with data, but why is it so important? Personal data is a really important asset to all organisations, and handling it in accordance with the law reduces the risk of something going wrong to that information. But I think it's fair to say that even if you consider all of the points on the previous slide and you put in place effective measures, it is sometimes the case that no organisation is infallible, and it's therefore important that all of your charity staff are aware of what to do in the event of a personal data breach. A personal data breach means a breach of security leading to the destruction, the loss, alteration, unauthorised disclosure of or access to personal data, so those points that you can see on the right hand side. So it means that a breach is more than just losing personal data, and I think it's key to remember that. Ensuring that any staff handling personal data in your charity know how to identify a breach is therefore essential. Under GDPR, those personal data breaches that are likely to result in a risk to the rights and freedoms of individuals will actually need to be reported to the ICO within 72 hours of that breach being detected. So that breach doesn't have to be detected by the data protection officer or a manager. It's basically at the first point where someone who's anyone knows that a breach has happened, that's when the 72 hours starts to tick. Such a breach, if unaddressed, is likely to have a significant detrimental effect on individuals. For example, it may result in discrimination, damage to reputation, financial loss, loss of confidentiality perhaps, or any other significant economic or social disadvantage. Each breach will need to be assessed on a case-by-case basis because the threshold to report a breach does depend on whether it's likely to impact on the rights of the individual. So, for example, you'll need to notify the ICO about a loss of donors' financial details where the breach leaves individuals open up to the risk of identity theft. But on the other hand, the loss or inappropriate alteration of an internal staff telephone list in your charity might not normally meet that criteria, so you might not have to report something to that. But the key is that you're assessing breaches on a case-by-case basis. And the reasons above hopefully demonstrate how important it is that all staff handling personal data are confident in knowing what to do if they find a breach has occurred. So regardless of job role, seniority, how long they've been in the job, it's back to that importance of training and knowing what to do if something goes wrong. Personal data breaches aside, another area that needs to be looked at within your charity under the current law and ahead of GDPR to make sure you're prepared is the area of direct marketing. If your charity instigates any direct marketing, whether it's by post, electronic means such as emails, text, phone calls or faxes, then it's essential to look at how you go about doing this. Direct marketing doesn't just apply to marketing for commercial reasons, so it doesn't just have to be something's being sold or kind of offered, but it also includes the promotion of a charity's aims or ideals. So charities are not only therefore subject to the rules set out in data protection laws, but also to the rules set out by the Privacy and Electronic Communication Regulations, which I referred to a couple times, but they're basically the regulations or the rules that you as a charity must follow if you're direct marketing individuals by electronic means. There's currently an e-privacy regulation on the horizon, so again, part of the data protection reform package, but until we know more about its content and how it will apply in the UK, the Privacy and Electronic Communication Regulations will still be the law that you need to comply with. So up until you hear otherwise, it's going to be the privacy regs that you should comply with. And the ICO's Guide to Direct Marketing, which you can see in a blurry format on the screen, contains all of the information you need to know in order to market individuals lawfully under both the current Data Protection Act and the Privacy and Electronic Regulations. So please do have a look at that on our website if you're interested in knowing more. And again, we did a previous webinar that does cover off the PECA side of things, so the privacy regulation side of things. Unfortunately, when things do go wrong under the Data Protection Act or the privacy regulations, and people's data is being used in ways that they weren't expecting, it's not only the reputational risk to your charity that faces being damaged, but it's also the risk to the rights and freedoms of your donors, service users, but also the trust that they have in you as a charity. So again, it really does highlight the need to put those previous measures we saw on that little slide with all the different bubbles with all the text. It's really important to put all of those into place and make sure that you're demonstrating how you're accountable, because all those in turn reduce the risk of something going wrong with data, and as a result of that, reducing the risk of someone losing trust or kind of faith in your charity. When we looked at the principles under GDPR, you'll remember that we looked at the new pseudo-principle of accountability. And again, just to recap, the accountability principle requires you as a charity to demonstrate how you're complying with GDPR. I normally compare this to the kind of, when you used to do a maths exam in school, you'd often get marks for getting the answer right. So if, for example, the answer was 20, but in addition to that, you'd often pick up points for actually showing your workings out as well. So they always encourage you to show your workings out. And if you compare this to complying with GDPR, it basically means that you're not just getting the answer right and you're complying with the law by luck, you're actively demonstrating to the ICO your compliance by putting certain measures in place. So the measures we saw on the screen previously and other measures as well. So there's a number of ways to demonstrate how you comply with the principle of GDPR. And again, I keep referring to it, but they can all be found in our overview of the GDPR document, but we'll take a look at a few now. So we've talked briefly about them, but using what we call data protection impact assessments will be mandatory under GDPR in certain circumstances. So those scenarios would be, first of all, if you're using any new technology. Or second of all, if the processing that you're starting to do is likely to result in a high risk to the rights and freedoms of individuals. So that's when they'll be mandatory under GDPR, but they'll also be encouraged wherever a new project or initiative is being rolled out that involves the collection or subsequent use of personal data. Again, just to get a feel for your familiarity with privacy impact assessments or data protection impact assessments, because we use the terms interchangeably, can I just get, by way of commenting in the box, just how familiar you are with them? So has your charity ever seen one? Have you ever conducted one at the beginning of a new project or initiative? So if you're willing to, and if you haven't heard of one, that's absolutely fine. You're welcome to comment that. It's just so we can get a feel for how much they're being used in the sector at present. So a couple of people typing.
Yep, so we've got, looks like quite a lot of people are typing in at the moment. No, so, right. So far then, we have mixed responses, I'd say. Some people haven't heard of the DPIAs before, have heard but haven't used one or seen an example. Yes, very little knowledge, never seen one, not familiar, heard of them, haven't used them.
Well, so a bit of and again, that's really useful for us as the regulator to see how much they're being utilised. But let's just look at why they're so useful for you as a charity. So an effective data protection impact assessment will really help your charity identify and therefore reduce the privacy risks that are associated with any new project or initiative that involves personal data. As you can see on the screen, the ICO's got a current code of practice on privacy impact assessment, so please feel free to have a look at that. And again, we use the current word privacy impact assessment, but GDPR slightly changes the terminology to data protection impact assessments, but they're very similar in that they're both an approach to look at privacy issues beforehand, rather than getting to the end of a project and thinking, oh dear, we didn't think of the data protection issues, and now, for example, we haven't got a lawful basis, or we haven't been able to tell individuals how we're using their data, for example. So that's one way of demonstrating accountability, having a good privacy impact assessment code of practice. And I think Emma and I were having a conversation earlier, and you can actually view a lot of PIAs that local authorities, for example, or other larger organisations have done. And even just reading one, or even just reading our privacy impact assessment code of practice, helps them make sense. So certainly have a read of one if you're looking for some nighttime reading about privacy issues, because I really would recommend having a look at what they kind of look like. Another way that lends itself to demonstrating accountability under the GDPR is by implementing a data protection by design and default approach. So this is quite similar to PIAs, but under the GDPR, you've got a general obligation to implement technical and organisational measures to show that you've considered an integrated data protection into your processing. So rather than just always thinking about data protection last, think of it at the beginning and make sure that you're always thinking of data protection by way of, for example, always collecting only the minimum information you need, so not collecting too much when you don't actually need it. So there's various ways of having that approach, and again, more guidance in our overview document. And under the Data Protection Act, this privacy by design approach has always kind of been an implicit requirement of the principles. So again, collecting personal information that's relevant and not excessive. And this has always been an approach that the ICO has consistently championed, but under GDPR, it's more of an explicit obligation for you to comply with. So just looping back to the importance of your role as a trustee, we do appreciate that it's sometimes difficult to have complete oversight of what's happening on the ground in terms of the day-to-day operations within your charity. So the slide you're looking at highlights the importance of having clear mechanisms in place for reporting any data protection concern. So that could be a concern about a breach that's occurred, so someone knows that they've disclosed something that they shouldn't have or lost something, but it could just be a general kind of data protection concern. Someone might be querying what to do in a particular circumstance, so someone might have requested their data and that member of staff doesn't know how to go about dealing with it. So it's about having clear reporting mechanisms in place. And those mechanisms will really ensure that any member of staff, regardless of job role, seniority, or how new they are to your charity, knows who to report any concerns to regarding data protection. Concerns can then be channeled through the team with data protection responsibility, who can then feed them up to the senior information risk owner if your charity has one. It's unlikely that you would have one, but if you do have one, and then they can then channel that concern up, or any other data protection issue that warrants the involvement of trustees, they can channel that up to make sure that it is on your radar at that stage. So it could be that not all issues need to be reported upwards, but those that really do need that clear reporting mechanism, it's important to have it in place. I've referred to the guidance that you can see on the left quite a few times already, but that's the overview of the GDPR document, and it's a really useful document which expands on much of what's been covered today. The 12 steps to take document on the right is what our first desktop data webinar in May 2017 was based on. So if you haven't had a listen and you think it would be useful, then please visit the WCVA's website, and if you search under the desktop data series, that comes up as the first one. And then that URL on the screen that you can see, that links to all of the GDPR guidance that we've got at the moment on the ICO's website. But again, if you've got any problems, we can send you guidance if you can't find certain bits of guidance. And finally, whilst I hope today's been really useful, please don't hesitate to contact the ICO's office in Wales for further advice and guidance. Your role as a trustee, and I said this earlier, will be essential in terms of helping your charity to comply with GDPR, so please remember that as the regulator, we are here to help. So thanks for taking the time to listen today or at a later date, and I'll now hand you back over to Emma to see if there's any more questions that you'd like answering. So thank you, Emma.
Thank you very much, Bethan. Much appreciated. Okay, so over to you then. Do you have any questions that you'd like to ask Bethan? I mean, we're very fortunate here at WCVA to have a representative, again, from the Information Commissioner's Office. So now's your chance if you do have any further questions about May 2018 and the General Data Protection Regulation. If you can type your questions in, please, that would be lovely. Yeah. So we'll just wait. I can see that a few people are typing in, and brilliant. Thank you, Richard. Okay, so can you speak briefly about legitimate consent?
Yep, so consent is back to one of those bases under GDPR that you need to meet, if you remember, you need to meet one lawful basis in order to process personal data. Our privacy notices and consent webinar in, I can't remember what month it is, but it'll be on the desktop data series. It covered the fact that GDPR quite significantly raises the standard of consent. So if you're relying on consent as part of your processing, for example, if you're getting consent for newsletters to send out electronically, then under the current law, if you've got a box that says untick this if you don't want to consent to this, then that's not brilliant under the current law, but under GDPR, that will actually be unlawful. So if you're getting consent under GDPR, so you've decided that that's your legal basis, you've looked at the 6 available, and consent is the option that you're left with, you need to make sure that that individual is taking a positive affirmative action to opt in. We've got good consent guidance on our website. It's actually in draft format at the moment, but if you're interested in finding out more, then please feel free to give me a ring and I can talk a bit more about your circumstances, or you can have a little Google on our website and see exactly what that consent document covers. But just remember, it's a higher standard and it should only be used if you're able to give someone complete control over how their data is used.
Thank you, Bethan. Okay, and yeah, like Bethan said, we did run a desktop data session on consent, so there's quite a lot of information in there. So we will try and get the link onto the chat pane. If not, we'll certainly be able to confirm which month we held that session in, so you can just check the WCVA website. Okay, and the next question, is there any specific documentation for information held about employees?
Yep, so we don't offer documentation by way of policies, etc., but the ICO has a really good employment code of practice. So again, if you type in employment to our website, it should come up. But it's the employment code of practice, and it basically sets out the types of issues you face as an employer and the collection and use of employees' data, those types of issues that you need to be familiar with.
Okay, great. And another question, will email marketing platforms like MailChimp be addressing this on our behalf?
Okay, so ultimately, under the GDPR and under the current law, if you're using a third party like MailChimp to send out mailings, you're still the data controller. So it's you that's saying to MailChimp, these are the individuals that have consented to receiving these newsletters, or other kind of, so e-newsletters. And you're ultimately the data controller. So you've got to make sure that when you're getting consent, you are doing it in a way that's GDPR compliant. So although MailChimp will be acting as what we call a data processor, so you're giving them the personal data, they're doing the job of sending that email out to each individual. You're ultimately the one that if there's any concerns, it would kind of come to you in the first instance.
Great, okay. and a comment about the overview. Thank you. And is data held about businesses and or organisations rather than individuals covered within GDPR?
That's a bit of a harder one to answer without knowing specifics. So, for example, if you're dealing with a sole trader and you can identify that living individual from their business name, then they would have rights in relation to that. In terms of marketing, there's slight differences in terms of if you're marketing an individual subscriber. So my email address, I'm happy to say it now, is bethan.bonsall@ico.org.uk. If you're then sending the same marketing newsletter but to Wales@ICO, so the email address you can see on the screen, then there's slightly different rules. So I've got more rights in relation to my email address, so bethan.bonsall, than I would that Wales@ICO example. So yes, GDPR can come into play, and so can the privacy regulations, but it does depend on the circumstance. The next question, so as a children's charity, you deal a lot with consent. In terms of the age of consent and GDPR, what we're saying is that if you're offering an online service, so what we call an information society service to children, so that's basically a kind of login that they can log in at a distance and access some sort of account, then if your basis is consent, so if you've looked at those 6 options under Article 6 and consent is the most appropriate one that you're going for, if that child's under the age of 13, then the UK government has said that that way of getting consent needs to be from their parent if the child is under 13. So it doesn't apply to all kind of consent. Again, with consent, if it's for something other than an online service, like an information society service, you might have another kind of way of getting parental consent, but GDPR only says you need parental consent in relation to online services.
Okay, great. And then another comment there regarding when the webinar was held and a link to that and various thanks. Thank you for that. And then a comment from Rafat, and my colleague Kath is currently typing away replying to that. So I think that ends the session today. So thank you very much once again, Bethan.
Thank you.
And thank you very much for your participation in the webinar. It is much appreciated.
Thank you, everyone. And the questions certainly make it more interesting and more valuable, I think, to everyone. So thank you.
So to help us to improve our future webinars, could we please ask if you would complete the short survey using the link provided on the current slide there. The link will also be circulated to everyone who attended. And our next session, interestingly, is on privacy by design. And that's going to be held at 2 o'clock on Monday, the 11th of December. In the meantime, if there are any topics that you'd like us to cover, please get in touch. And we look forward to you joining us again next month.